Hi, I'm Annie Fitzsimmons. I'm your Washington REALTORS Legal Hotline Lawyer. In today's sellers-driven marketplace, buyers are incentivized to put the largest amount down that they can. So buyers, in writing their Form 22A financing contingency, like to put 20, 25%, 30% as their down payment, which is in many cases eye-catching to the seller because the seller then believes, wow, this buyer is really well qualified, they've got a big cash reserve, they have more flexibility in the type of loan that they're going to get, well-qualified buyer, I should choose this buyer over another buyer. The problem is that large down payment is not necessarily reflective of what the buyer is really doing. And I have heard some disturbing fact patterns over recent weeks. For example, buyer puts that financing contingency into their offer, and as also part of their offer, buyer includes a Form 22AW, which is the limited waiver of financing. So in essence, buyer includes a financing contingency and in the same offer waives their financing contingency, but the 22AW limited waiver of financing actually preserves the low appraisal provision from the financing contingency. So when it's all said and done, with these two forms together as part of buyer's offer once seller accepts it, buyer has the benefit of a low appraisal provision. No financing contingency, but a low appraisal provision. So what's the psychology of making an offer with those two forms rather than just including a 22AA, which is in fact the low appraisal provision addendum? Well, the psychology of that offer is nothing other than deception. Buyer makes a representation to seller, I'm putting, let's say, 25% down, and then waives their financing contingency, preserving the low appraisal provision. And in reality, behind the scenes, buyer has no intention of putting 25% down. Buyer is going to put something substantially less than 25% down. And then they're either going to get a loan for, let's say, 95% of the purchase price, I'm making that number up, or let's say they're going to go get a combination of loans, a conforming loan up to this amount plus a second loan to make up the difference. But in any event, they are not pulling 25% of their own cash reserves out in order to fund the purchase of this property. So why did they say that on their financing contingency? There's only one reason. And the reason is that the buyer wanted to create the impression in the mind of the seller that the buyer was more qualified than the buyer is. And when challenged on this, the buyer broker's response was, no harm, no foul, because buyer's not got the benefit of the financing contingency. So why does it matter to seller if seller believes buyer's putting 25% down when buyer's really not putting 25% down? Of course, the best way to confront that argument is to ask the question, why then did buyers say they were putting 25% down if they're really not in an artificial financing contingency request? And the answer, of course, is that buyer was trying to get seller to believe that buyer was putting 25% down. In other words, it is a deception. Said differently, it is fraud. I, again, have given you a fairly complicated fact pattern that is real life in some scenarios that I've heard about around the state. But it doesn't even have to be that contrived to still be deception or to still be fraud. Maybe buyer gets a pre-approval letter from a lender by telling lender, I've got cash reserves to put 25% down. But in reality, buyer doesn't have that. Buyer thinks they're going to borrow the money from it. Grandma, or they're going to sell something, or they're going to pull it out of a different, wherever, right? It's not their cash reserves. Many lenders don't verify cash reserves before they issue a pre-approval letter. They trust the buyer when the buyer says that the buyer has these cash reserves, and they issue a pre-approval letter. That is every bit as deceptive as the first fact pattern I gave you. And here's the problem. When a buyer intentionally deceives the seller, making the seller believe that the buyer has a greater financial capacity than the buyer actually has, buyer commits an act that the law recognizes as fraudulent inducement. And the word fraud in fraudulent inducement is not an accident. Buyer has engaged in fraud. Why is that significant? Because in most residential real estate transactions, buyer is protected by the forfeiture of earnest money provision in the standardized purchase and sale agreement. If buyer engages in fraud, believing that buyer is protected by the forfeiture of earnest money provision, in other words, the most I have to lose is my $2,000 earnest money, buyer is dead wrong. Because if a court finds that buyer engaged in fraud, then a court can undo that forfeiture of earnest money provision and allow seller to seek a damages claim against buyer for seller's actual damages. And if seller is damaged in an amount, actually damaged in an amount greater than $2,000, which I'm making up as the earnest money in this analogy, then the court will award seller the actual amount of seller's damages, plus in most cases, attorney fees and costs. In other words, the risk to buyer for engaging in fraud is real and it is enormous. And brokers, buyer brokers, if you assist your client in deceiving the seller, shame on you, but in addition, you violated the agency law. You violated the duty to disclose material facts, the duty to exercise reasonable skill and care, and the duty to proceed in honesty and good faith with respect to your dealings with the other party. This is a troubling trend in our industry. While it is important for buyers and buyer brokers to put their absolute best foot forward in a transaction, it is not okay for buyers or buyer brokers to deceive the seller and trick the seller into picking this particular buyer over another buyer based on an artificial presentation of buyer's abilities. Buyer brokers, please do not engage in these tactics. Realtors, you're better than that. If you have questions on this topic or any other, please send an email to me, legalhotline@warealtor.org. Thank you for being a Washington Realtors member.